Good morning. My name is Sarah Fossils. I serve as the Board Administrator for the Texas State Board of Social Worker Examiners. I'd like to begin with a roll call. Chair Brumley.
I am present.
Ms. Andrade.
I am present.
Mr. Morris.
Present.
Ms. Mosier.
I'm present.
Ms. Ramsbacher.
Present.
Ms. Rogers.
Present.
Ms. Sáenz Davila. Can you unmute?
Sorry, present.
Excellent. And Ms. Swartz.
Present.
Thank you very much, board members. Welcome to your meeting. I'll turn it over to Chair Brumley.
All right. Thank y'all for showing up this morning. It's now 8:37 for those that are joining the meeting. We had some, of course, technical issues getting everybody on and live, but we wanted everybody to be ready for today's meeting. So we will call the meeting to order. And the first item of business today will be item number 2 on your agenda, which is the approval of minutes from the April 2nd, 2021 video conference board meeting. If everyone has had opportunity to review those minutes, I would entertain a motion for approval of those minutes at this time.
I'll make a motion to approve those minutes from the April 2nd meeting.
Okay, we have a motion from Martha. Anyone want to second that?
I'll second it.
I didn't see who that was.
Audrey.
Audrey. Okay, Audrey seconded it. This is kind of like playing whack-a-mole, following this box around. So we have a motion and a second. All those in favor, please signify by raising your hand and saying aye.
Aye.
So the motion does carry and pass. So those agenda item number 2 is complete. So next we have item number 3, which is discussion and possible action concerning preparation and maintenance of meeting minutes or recording of each open meeting per Texas Government Code 551.021 and 551.022. So this is an item that we had discussed at the April meeting. And I don't know if Sarah or Daryl, do either of y'all want to address this or we move forward?
Yeah, Chair Brumley, before we go forward, let me just ask, is everybody, you mentioned you were having trouble following the box around. Are you looking at us all in gallery view, Chair?
I am.
Okay. Sarah, is yours set to gallery view as well?
Yes.
Okay. I just checking to make sure. I didn't want us to have it on speaker view, and that is difficult to follow.
No, yeah, I could
okay.
never do that. So.
Okay. All right. Yeah, the meeting minutes. We have now had, of course, the council has switched over to recordings only. They've moved away from written minutes. Psych board has done that as well. LPC board has done that as well. We've got to do a rule change at the LPC board. And so I think we had talked about doing this last time. I can't remember too much about what the discussion was last time, other than we were going to look at it a little bit more. Of course, we've got the YouTube channel up and running. YouTube will generate basically a closed caption transcript of the meeting on its own. Of course, we have, let me turn on the closed captioning for us here as well. We have the capability of doing that. So, and I think that was some of the things we were going to look at last time, is see what our transcript and what our closed captioning capabilities were. So we've got that. AI does it for us. I don't have the manpower or the time to sit and have somebody actually type it out. YouTube has that feature, but and then it would save it for later date. But I don't have that time or the resources available to do that. We have to rely on the AI to do that for us. But basically what I'm doing is I'm going to each of the boards and asking them, would y'all be willing to transition over to just the video recording that we post on YouTube to serve as the official record of the meeting? The law allows that in lieu of written minutes. Every minute or bundle of minutes that I can save Sarah or staff from having to do this stuff, we can apply in different areas of the agency operation. So I know while people say, well, I'm looking at these minutes, Daryl, and they're only, a page and a half or whatever they are. I haven't looked at this meetings, but, they're very short. There's a lot more work that goes into prepping a page or a page and a half worth of minutes than just what you're looking at. So yes, I may be only talking about saving, a couple hours of time with staff, but that's a couple hours that I could be working on candidly other high priority tasks, or that Sarah could be working on bigger ticket items. So we're professional anglers. We go after big fish. And so I would like permission to go after big fish and not be a shrimp trawler and be going after all the little stuff out there. So that's why I'm asking all the boards to transition to this, but it is y'all's call.
All right. Well, following that fishing analogy, you've set the bait. So we discussed this before, and if everyone, if your recall is set, we talked about that it is able to be tabbed so that someone doesn't have to listen to the whole meeting. They can go to a portion that they are interested in, and that allows for the public to save time in finding what they are actually interested in. So I think that was the feature that I was concerned about. So I would entertain a motion that we take action and approve for the minutes of the Texas State Board of Social Work Examiners to be recorded and then posted to the YouTube channel for public consideration. So anyone want to make a motion for that?
This is Martha. I'll make a motion to approve recording minutes and posting them up to the YouTube channel.
Okay. A second.
I'll second that.
That was Audrey who made that second. So we have a motion and a second. All those in favor, please signify by saying aye and raising your hand.
Aye.
So
Aye.
motion does carry. And from today forward, I'm assuming Director Spinks, these will be posted on the YouTube channel.
Yes, sir.
Okay. So from
And just,
today's, yes.
yeah, I was going to say, and just always know if something were to happen, for whatever reason, we can always prepare written minutes in lieu. We've got to have a record one way or the other. So if something were to happen where the recording got fouled up or whatever, we would just go ahead and revert back to what we did for that particular meeting of doing a written minutes for the meeting. So we've got a fallback position.
And Daryl, clarify for me, is it actually the video and the verbal part of the meeting, or is it just the written, the audio part?
No, we do video.
Okay, so it would be actually what we're seeing now would be
Correct. Correct. Yeah, and I've made sure to go in the webinar settings, and when you record a webinar, I've got kind of a master setting to where it should be recording us all in gallery view.
Okay.
And when we share screen, I think I've got it set to where the gallery view, it's either gallery or speaker view is on while we've got a shared screen up, so that later on people will also be able to see whatever it was shared on the screen in the recording as well. So I've tried to kind of where you can figure out what in the world we're talking about, what's going on if you're looking at this thing 3 years from now after we've all spent.
Okay. Well, that sounds like a move to the future. So good deal. All right. So that takes us to item number 4, which is board review and possible action. Let me get my glasses here. Regarding appeals and application for licensure denials, including Stephen Johnson and Otha Norton. So I will defer to Sarah.
So I see that Stephen Johnson is one of the attendees. I do not find Mr. Norton. And I believe that the meeting notice to Mr. Johnson offered him 10 minutes to speak to the board if he chose to, and then the board could discuss his case. So if that's all right to proceed that way, then I'll proceed with asking Mr. Johnson to speak.
All right. So Mr. Johnson, if you're there, Sarah's going to open you to the board.
Mr. Johnson?
He's on mute.
Unmute me,
There
please.
you go.
Can you hear me?
Yes,
We
sir.
can.
Okay, I cannot see you all. I'm having trouble with the computer. Good morning, everyone. Thank you all for, I would like to thank the council for meeting and reviewing my application, please. I'm having trouble with the Zoom. I'm not seeing anyone. I'm not sure if I'm doing this properly, but I can hear you all. Yes, sir. No. Hello? Can you all?
Yes.
Yeah, we're
Okay.
here, Mr. Johnson. We hear you perfectly fine.
Okay. Yes, sir. I'm having trouble with the Zoom. But anyway, sir, I thank the board. I thank the council for meeting with me today, even though I'm having problems with the Zoom. I'm not good with it. I just thank you all for meeting with me today. And I really, I'm asking you all to consider me for my license back again. One thing that I would like to say that I am receiving government assistance right now. And then as far as food stamps and things like that, I would like to become self-sufficient again as far as being sufficient. And I am aware that I'm a little nervous, you all, because it is Zoom, but I'm aware that I do take responsibility for all the previous actions that was done. I do take responsibility for my actions. And I have also been in counseling services as well as part of TDC and everything. And I also would like to be considered back as, I don't know if you all looked at my paperwork, but it was a situation, a matter that occurred back in 2005. I apologize, y'all. Please ask me some questions because I'm nervous and I don't see anyone and Zoom is not working well for me. I'm nervous.
So, Mr. Johnson, this is Chair Brumley.
Yes.
Could you explain? So you talked about you're receiving counseling services. Can you give us sort of a synopsis? Not any protected health information, but just a synopsis of kind of how you feel that's being successful.
Oh yes, sir. Currently, I do take therapy sessions, and I am receiving sessions. And one thing that I would like to say is, over the years, it has allowed me to recognize where I did the error, where I was at fault, where I was at error, and I take responsibility for that back in 2005. And I just want you all to know that the initial situation was a situation with me and my family. I had never did any harm to a client. And I really would like to get my license back so I can become self-sufficient. And then on top of that, I would like to work with the organization that I would like to work with. I know that being a social worker, helping people and taking care of the community is part of what I like to do. And growing up, being a social worker, it really was something that was brought up on me accidentally growing up, because as a kid, I remember my parents, my mother, she she worked with a social worker. And growing up, I did not know it until I was older that I also wanted to be a social worker. And that is where I'm at right now in my life. And I really appreciate it that you all take consideration in regards to the information that I have submitted to you all. And I do take responsibility from the former for the situation.
Do any other board members have any questions for Mr. Johnson?
Yeah, this is Martha. I do. So, Mr. Johnson, when I kind of looked through all of the documentation that you submitted to us, and thank you very much for that. I really do appreciate you taking the time to really submit all of that information. But, you know, when all of this occurred, you were a licensed social worker.
Yes,
if I'm looking at the information correctly. So please correct me if I'm wrong, but that you had been a licensed social worker starting from the year 2002 through 2009. Is that correct?
correct.
And so all of these, the incidences that we're referring to you started, looks like around and from 2006 through 2009. So that is a concern to me that you were licensed, you were being held to that code of conduct and those behaviors when this was occurring. So as for me as a board member, how can I be assured that you are very familiar with what that code of conduct and what those behaviors are required of you in order to protect the public that is out there that you may be serving?
In regards to the code, of conduct, ma'am, I have been reviewing everything in regards to what the social worker requires and what it requires for the compliance with state and federal law. And
Is that a train going by, Mr. Johnson?
No, that's me. My office is about a block from the train tracks.
Oh, okay.
I can mute for a moment.
Okay. Go ahead, Mr. Johnson.
it's just my concern is that I would like to get my license back so that I could become an efficient member of the community once again. And then on top of that, relates to
Mr. Johnson, what directly to Ms. Mosier's question, she was asking how she can feel comfortable that the rehabilitation that you've done will now continue, and you will be an upright citizen basically, and follow the rules of social work.
Yes, sir. I will be, and I've always been a good social worker. And one thing about being a social worker, it allows me to help the community that I serve. And as far as me, doing counseling and doing having professionals that I also talk with on a regular basis, social workers who are in the field of social work, that allows me to stay focused in regards to the profession. And also it allows me to stay focused in regards to what are the outcomes in regards to patient safety, what are the outcomes for taking care of the patient and making sure I'm doing the right thing with the patient and for the patient. As you all know, I did state that this was a family matter that happened many years ago. I did take responsibility for it, and I continue to. In regards to counseling, I stay connected to professionals, and then I also have been receiving counseling from Mr. Bob Hergenroder. He's a professional counselor that I normally see and talk with in regards to this situation.
Have you taken any continuing education courses during this time?
Currently, no, sir, I'm not, but I'm willing to take continuing education classes and whatever stipulations that the board may want to place on me in order for me to become a proficient and good member of the board once again, because this is our profession and I would love to be back in it.
Okay. So, Sarah, what do we need to do at this point? I know that 10 minutes is now approaching time.
So I'll refer to Attorney Andrew or Attorney Patrick, because I believe there might be some statute that may constrain the board's action.
Okay.
Right, Andrew, do you want to talk about Chapter 108 for a moment?
Sure. Chapter 108 states, bring it up so I can quote directly from it. Chapter 108 states a licensing authority, such as the board, shall deny an application for a license as a healthcare professional, which includes social workers, for an applicant who is required to register as a sex offender under Chapter 62 of the Code of Criminal Procedure. And the information I have in front of me, Mr. Johnson, you are currently registered as a sex offender. Is that correct?
Yes, I am.
And you have a projected ending registration date of October 4th, 2027. Is that correct?
Yes, sir.
Okay. My recommendation to the board is that the legislature deny the application. The legislature is not giving the board any leeway or discretion in approving applications such as this. There may be ability for Mr. Johnson to get his license back after October 4th, 2027. But at this time, I do not believe the board has any discretion in denying the application.
Okay, thank you. Thank
Mr.
you,
Johnson.
Attorney Hurd.
So just so that I understand this, this is Martha. I just wanted to make sure I understand, so that his registration as a sex offender, that mandate ends in 2027. So at that point, then, under the legislative constraints and regulations that we have, he could apply at that point.
I believe so. Mr. Johnson is no longer incarcerated. He is no longer under any kind of post-judgment court supervision or anything like that. Just the sex offender registration. So I believe he may be able to get his license back at 2027. That would also, but it would also have to be reviewed by the board at that point again.
To Andrew, that 108 under 108 under 3, it talks about there are certain codes of the penal code that if you're convicted or placed on deferred under those, are any of those the offense for which Mr. Johnson was placed on registration? Do we know?
I would have to review that.
My point being is even if he's off registration, if the underlying conviction is one of those offenses, he's ineligible forever.
Let me double check.
Now, Mr. Johnson, let me ask you real quick.
Yes, sir.
Are you have you looked into the possibility of coming off of registration early? I know there used to be a mechanism where you could get deregistered. When I was practicing it, it was fairly new, but
It's administered by the Council on Sex Offender Treatment under HHSC. He can, if he might be eligible to participate in that program.
the deregistration.
Yes.
That might be something, Mr. Johnson. That's
Yes,
my
sir.
suggestion would be I would go talk to a lawyer and see about deregistration. But before you spend the money on that, let me
Yes.
also suggest, can you see our faces, Mr. Johnson? Can you see the screen?
I can see you all's faces, yes.
Okay, hang on just a second. I'm gonna share a screen with you here. I'm gonna show you the law, and I want you to write these penal code provisions down that
Yes,
I'm
sir.
about to show you, okay?
Yes, sir.
Okay, can you see where I've got highlighted right here?
Section 108.052.
All right. Yes, sir. I want you to look and see, after we get done here, you go look and see on your court paperwork what you were actually convicted of. Is it one of these offenses that I've got highlighted right here? If it is, unfortunately, you will never be eligible for licensure again as a social worker in Texas. If it's not one of those offenses, then you need to go look to see about the possibility of deregistration if you want to try and become licensed prior to 2027, the expiration date for your current registration, okay?
Yes, sir. 22. What I would find this information in Texas.
It'll be really what you need to do is you need to look on your judgment, the judgment of conviction, or order of, I don't know if you were placed on deferred or some sort of, what your disposition was, but you need to look and see if the underlying offense is in one of these penal code provisions. You understand what I'm saying?
Yes, sir. Yes, sir.
Okay.
I'm trying to write these down as we speak, so I won't lose it. 2204. And I have one other question in regards to this information right here. How can I find, do I need to go to the courts or what? Because that was 2017.
You can always get a copy of your judgment or the order from the district clerk in the county where you were placed on probation or sentenced.
So, okay.
You can always get it there because it's a public record.
Okay. Thank you.
Thank you, Mr. Johnson.
Don't give up hope yet. Just, you got to run the traps to see what you're capable, see what your options are. Okay.
Yes, sir. I really
Okay.
appreciate y'all for helping me with this, and sorry about the Zoom situation. Just caught me off track this morning.
We have the same issue.
Okay,
right. Thank you
and
again,
then
Mr.
once I get
Johnson, for
this-
joining us today.
let me ask you, once I get this information, can I call or write Mr. Hurt?
Yeah, if you haven't, if you have any other questions, you can reach out to Mr. Hurt. Yeah.
Okay.
Yeah, I'll help you out as best I can. But again,
We can't give you legal advice. We can't be your
I
lawyers.
understand.
We
Right.
are government lawyers. We represent the state.
yeah,
So, we can't advise you really in that route, but
Right, I understand.
but unfortunately, as long as you're a registered sex offender, that's the main impediment at this point.
Okay. So I need to try to take care of that.
Yes.
Yes, sir. I do believe the board needs to still take a vote on it, but that is my recommendation.
Say that again, Andrew. I missed part of that.
I believe the board would need to take a vote on whether to approve or deny the application.
Okay. So, based on the information provided by Mr. Stephen Johnson and by Attorney Andrew Hurt, I would open for a motion on the matter of item number 4 on the agenda, the action regarding the appeals for application concerning Stephen Johnson.
This is Martha. I'll make a motion to deny the application of Mr. Stephen Johnson.
I'll second that motion.
So we have a motion and a second. Motion from Martha Mosier, second from Ben Morris, to deny the application of Stephen Johnson. All those in favor signify by saying aye and raising your hand.
Aye.
Aye.
Motion carries. The application is now denied. So Sarah, did Mr. Norton join us, or do you see?
So thank you, Mr. Johnson. I'm going to mute your line again. I'm checking for Mr. Norton. I have one person who called in by phone. So I'll see if that caller happens to be Mr. Norton. Good morning, caller. Are you Mr. Norton? Caller, I've asked you to unmute. Are you Otha Norton?
I believe it's *67 to unmute.
take that as a no.
Okay, so with hearing that, we still need to, Andrew or Patrick, we still need to take action on Mr. Norton's action.
Correct.
Mr. Norton's request. So in reading the materials, Mr. Norton's history, if my notes are correct, was back in 1991, but it was for aggravated robbery and aggravated. Will one of y'all give us what the legal definition of aggravated means?
I do have that up. A person commits an offense if he commits robbery as defined in section 29.02, and he caused serious bodily injury to another, or uses or exhibits a deadly weapon, or causes bodily injury to another person, or threatens or places another person in imminent bodily injury or death. The other person is 65 years or older, or a disabled person. An offense under this section is a felony of the first degree. And again, this is under that 108 statute that I believe the legislature does not give the board any discretion in denying the application.
Okay, thank you. Thank you, Attorney Hurt. So hearing that, does it also fall under one of the 22 codes that Daryl was talking about that lasts forever?
Let me see.
I don't think ag robbery is that. I think those are assault and sexual assault
Okay.
offenses. The
It
22
is
are.
listed in 42A. So you have the ability to deny the application forever. Let me look at 108, but I believe with under 108, there is no timeline on it that
Okay.
they say you don't have the discretion to deny.
So once we take a vote in our action, Sarah, they receive an official letter from us stating that this is now in force.
Yep.
Yes, any appellant or respondent receives a post-meeting letter as to what the board determined and what their next steps, if any, are.
Okay. So based on Attorney Hurt's information regarding Section 108, I would entertain a motion concerning the application request of Otha Norton.
So based on what Attorney Hurt said, we don't have any leeway with this other than to make, and so I guess my motion is that we deny the application for licensure at this point.
Okay, we have a motion by Ms. Mosier.
I'll second the motion.
Have a second by Mr. Morris. All those in favor of denying the application request by Otha Norton, please signify by saying aye and raising your hand.
Aye.
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 Okay, any opposed? All right, seeing none, the motion does carry and the application for Otha Norton is denied. If Mr. Norton, if you are out there, you may contact the office for, or you will receive information from the office concerning the findings today. All right, that carries us to item number 5, which is board review and possible action regarding agreed orders to be executed by the board.
There are none for the board to consider today.
All right, that was easy enough. So we'll move to item number 6, board review and possible action regarding contested cases from the State Office of Administrative Hearings, otherwise known as SOA, including proposal for decision in the matter of Kimberly Hanchette, SOA docket number 510-21-0627. And I believe that's why Mr. Bridges is here. Is that correct?
Yes, sir.
Okay.
Ms. Hanchette was erroneously awarded a license under HHSC. She does not have a bachelor's degree in social work, and her degree program was not certified by the Council on Social Work Education. She was given an opportunity to present why her license, and she was given the license. And then when the mistake was discovered, she was given an opportunity to explain why her license should not be taken away. She didn't present any compelling information. It was asked that her license be taken away. She recused. She did not surrender it. And so I took it to SOA, and the proposal for decision says the license should be taken away.
Correct. And those of you board members, you had lots of documents and an audio file that was 2 hours long to listen to if you wanted to hear the whole hearing. And then the findings from the SOA judge, which when you get down to that last sentence says that the license should be denied or removed from Ms. Hanchett. So
I do see Ms. Kimberly Hanchette as an attendee. Does she have an opportunity to speak to the board?
She does. She wanted to present some ideas. We're not taking, we shouldn't be considering new evidence about the decision, but she wanted to make some statements on how she could close up shop. And she does have current clients and current obligations.
And I'm sorry, I don't remember if Ms. Hanchett is represented by an attorney, and I don't remember that attorney's name. So I
She's
don't know.
represented by Nikita Archie.
She's got her hand up, Sarah, in the attendee list.
There it is. So I'm gonna allow Ms. Archie to unmute. Ms. Archie, can you hear us?
Yes, ma'am. Good morning.
Good
good
morning.
morning.
Good
And
morning.
let me find your client, Ms. Hanchette.
Okay, thank you.
Ms. Hanchette, are you able to unmute?
Yes, I am.
Thank you. If you have anything you'd like to present to the board, we have
Yes.
about 10 minutes for you.
Okay, good morning. My name is Attorney Nikita Archie. I represent Ms. Kimberly Hanchette, and I'll be before you brief because, again, this is an opportunity for my client to present some alternatives to what we consider a very unfortunate and a untimely situation due to the board's error in the issuing the license has been stated. There was reference to the proposal for a decision that was made. And I'd just like to read some of the other comments that the judge made or opinions that she made in the proposal for decision as well. Specifically on page 14, the judge stated that this case is difficult, however, because respondent has now been licensed for 3 years. There's no evidence of any wrongdoing by respondent, and she provided persuasive evidence that she upholds a high professional standard and her work since licensure has been competent. The ALJ has no doubt the respondent is providing real services to real people, and that such services are valuable. In addition, despite the lack of social work degree, there is no indication the respondent does not have the specific knowledge, skills, and abilities to perform her current role. Respondent emphasizes that she exercised full disclosure, was diligent, and relied on the licensure process. Further, she states that if her license is revoked, she will be disenfranchised of her right to practice social work. And in closing, the administrative law judge encourages and urges the council, because the council admits respondent's license was issued in error, the ALJ concludes that it is reasonable for BHEC to work with respondent in good faith to minimize disruptions to her current contractual obligations to the extent possible. So in that same spirit, I ask the board and the council to work with my client to minimize disruptions in her current contractual obligations, and you will hear from her now to that extent. Thank you. Ms. Hanchette?
Yes, I'm here. I'd like to say, due to this immense error by the Social Work Board, I am being forced to greatly adjust my career trajectory. Currently, I'm under contract with Mental Health Concepts. And now that the economy has opened up again, I expect to start gaining clients again this month as soon as next week. I have and will continue to uphold professional standard and the code of conduct as a social worker. There is no issue of public safety regarding my clients. I have continued to carry malpractice insurance, and by no longer having my social worker license, it will have a great financial impact and adjustment financially. I am the main provider of my household, and a household of 3 generations, my daughter and my granddaughter. My salary will immensely decrease if my license is revoked. again, it affects my career trajectory that, I have planned for myself and my family. And I would just like to, as my attorney stated, if the board would work with me so that I can have time to search for a new career or gainful employment with not having a license anymore. And I have a couple of questions for the board if I'm able to do so.
You can ask. I don't believe the board is obligated to answer, but you can certainly ask your questions.
Okay. On the licensing area where anyone can search online, the database, will there be provided some sort of notation on my license as to why my license is being revoked?
No, ma'am. It will just receive whatever the standard response is for what we enter in the database. There's not going to be any kind of special notation.
So do you
Okay.
all have any recommendations on how she explains that to prospective clients and employers that her license was revoked with no explanation that it was issued in error, the reason it was revoked and not because of some disciplinary or administrative sanction or action?
I would suggest giving a copy of the PFD. That ought to provide a pretty good explanation that the license was issued in error.
And then what kind of career alternatives can you all suggest for someone who will essentially going from a license holder to a certificate holder as a social worker? What career alternatives are there?
Well, what certificate are we talking about here?
She has a certificate now, an LCDC, I believe, Ms. Hanchette, and as well as
Yes.
she's pursuing another certificate. So as soon as her license is revoked, her distinction will go from instead of LBSW, which clearly that's going to be revoked, to just her certificate holder status, which was her certificates that she was pursuing to complement her social work career, her licensed chemical dependency and other certifications in that area.
Well, she would be a licensed chemical dependency counselor at that point, but she would not be a licensed social worker any longer. As far as career advice, we really can't give any kind of career advice. I don't know what to tell you there.
Okay, not necessarily career advice, but what career alternatives are you aware of for someone in this position?
I don't know.
I can maybe answer some of that for you, Miss Archie. Working at a university setting, I deal with lots of agencies that do seek out LCDC certified individuals. And so any agency working with individuals who are experiencing addiction issues would be a good place to start looking for employment.
Okay, and then finally, what measures or controls will be put in place so this does not happen to any other applicant during the licensure process? I understand that this may be a case of first impression, but it's very unfortunate that my client has to suffer the oversight of the board in issuing this license. So what type of controls are going to be put in place to make sure that this isn't done again or happen again to another licensee?
BHEC has control of it now. That's the measures that have been put in place.
I don't think I'm quite clear.
The
on what-
Executive Council regulatory authority over this program has been transferred to the Behavioral Health Executive Council. That's the measure that's been put in place.
To remedy giving license in error? Because it is the
No,
board that issues it, correct?
No, you were asking about what measures have been put in place to make sure this doesn't happen again. The legislature has transferred regulatory authority over issuing licenses to the Executive Council. We
Okay,
now
that was in September of 2019? With
Yes.
the legislative change?
Yes.
So that September 2019 change addresses my client's issue today about her license being issued in error and being revoked?
Well, you were asking about what measures have been put in place to make sure it doesn't happen again. Those are the measures that have been put into place.
Thank you. And then finally, my client's license was issued through November with an expiration date, well, renewed, excuse me, issued and then effectively renewed for the 2-year term in November 2019, which will expire in November 2021. I'll let her speak to, again, what options that she has or would like to propose for consideration, because again, as she stated, she is currently under contract and her license originally was not set to expire when issued in error and renewed in error until November of this year. So Ms. Hanchette.
Okay, like I said, I'm currently under contract with Mental Health Concepts. And I would like to be given a chance to continue my contract until November, at least until November. And during that time, I can make adjustments financially to my household so that I will be able to, as much as possible anyway, handle my finances for my household and by being the provider of my household. I would like to be given that chance to adjust.
You talking about November of this year?
That is correct.
For the board's consideration, that I believe that the order for revocation, the usual process is that it is presented to the Texas Behavioral Health Executive Council. And the next date that that council convenes is August 24th.
Is it 23rd or 24th?
24th.
Okay.
And the recommendation from there is to give 30 days after that, which would then set revocation at September 24th. So
that's a staff recommendation, correct, John?
Correct.
That's just what we have in the draft order that's going before
Correct.
y'all. The board has discretion in setting, they can plug in whatever number they want to there, really.
Correct.
So Daryl, would we at this board, at the social work board, make a recommendation to BHEC for a future date?
You could, you could, instead of saying 30 days beyond the date of approval or execution, you could say by a date certain and plug in, I don't remember now, whatever date Ms. Hanchette said there. You could do that.
So Sarah, licenses do licenses expire on the first date of the month, or are they on a specific date?
They expire on the last day of the birth month. So it would be the last day of November.
The last day
if the
of
license
November.
expires in November.
Okay. So I would entertain a motion and consideration of the request of Ms. Hanchette and her attorney, Ms. Archie, for consideration of a specific date for the expiration and revocation of Ms. Hanchette's license.
This is Martha. I will make a motion that Ms. Hanchette's license does not expire, or I guess it's not revoked until that expiration date of November 30th, 2021.
Okay, we have a motion.
I second.
We have a second by Ms. Ramsbacher. So all those in favor of the recommendation made by Ms. Mosier, please signify by saying aye and raising your hand.
Aye.
Aye.
Any opposed? Seeing none, we will make recommendation. Now, understand, this is a recommendation that will be sent to BHEC for consideration. The actual vote will take place at the August 24th meeting at BHEC. But that is the recommendation as it stands now.
Good, thank you.
I appreciate that.
Thank you, Ms. Hanchette. Thank you, Ms. Archie.
Yes, thank you.
Thank you.
Okay. That moves to item number 7, which is report of agreed orders executed by the council's executive director, including And there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, I believe, orders that I will allow. I guess, Daryl, are you taking charge of that? Where'd you go? There you are.
So those materials were included in your packet, just for your information.
Okay.
I don't have anything particular to present. These are cases that were reviewed by staff and executed by Daryl, the executive director, on behalf of the board and the council. So if you have any questions in that regard, we can note those questions and get the information you request to you.
Okay. Does anyone have any questions concerning any of those numbers? And if need be, for the record, I can read them. It's 1072-16-143 concerning RM 1072-17-027 concerning TO 1072-17-0062 concerning SD 1072-17-0140 concerning PS 1072-18-0032 concerning LP 1072-19-0079 concerning TR 1072-19-0083 concerning TG 1072-20-0003 concerning SB and 2021-00237 concerning MPS. Does anybody have any specific questions concerning any of these orders?
I did not have any questions.
Okay, so no one's asking questions. So, we do need to take action on this, correct, Sarah? We need to vote to. We don't, Patrick. Okay, we have just reviewed these, and these orders are now able to be submitted or sent out. Okay.
They've been executed and they're available for the public on the online license verification system.
Okay.
And they were also part of the public's meeting materials for this meeting.
Okay. All right. Thank you. So next we will have agenda item number 8, which is a report of cases dismissed by the council's executive director.
And that report was in your meeting materials. If you have any questions, I'll do what I can to answer them.
So anyone have any questions concerning the dismissals? All right, hearing none. That material is also provided for everyone, so you can see that at your leisure. Agenda item number 9, status report of quarterly enforcement case activities.
So that was in your, that's in your meeting materials. That's the quarterly report for all of BHEC with details about certain things for each of the member boards. If you have any questions, we can field those questions.
Any questions concerning that quarterly status report? All right, hearing none, we will move on to that was did we just do number 10? I'm getting lost in my numbers now. Yeah.
You just did I think it was number 9.
Number 9. We're now on the report of agreed orders, yes, which is also included in our packet of materials.
Correct.
And if anyone has questions on any of the agreed orders that have been submitted. All right, hearing none, we will move forward with that. To item number 11, this is report from committee chairs. So we will have 4 opportunities here. First is the ethics committee chair. And that being me, I have no information to report from the ethics committee since our meeting in April. So I will now turn over to Ms. Mosier for licensing standards and qualification committee.
Yes, the Licensing Standards and Qualification Committee, we met in March, I believe March 26th. And on that day, we reviewed one case in terms of licensing and standards and had one case to discuss regarding a supervision plan and the number of years in acquiring the amount of time for supervised experience. The time was significantly past that 48 months for getting the experience and 5 years for sitting for the examination. And that time limit had expired. So we did not approve some of those hours in that time. We did approve some of it and approved her continuing to move forward then with that supervision plan that she was currently under.
All right, thank you, Ms. Mosier, for that. Being that these are reports, they do not require action from the board. So next we have the Professional Development Committee, and that again being me. I know Sarah has submitted, Sarah and I don't remember the number. We've over between April and now, we have reviewed several of whittling down the number of AMEC participants.
The Professional Development Committee has approved 4 participants in since your last meeting.
Okay.
And that is the end of the active participants in AMEC. So you will see no more of those.
All right, thank you. So those of you that are out there in the public listening, AMEC was and is now officially today over a program called Alternative Method for Exam Certification. It was put in place, I don't remember when, many years ago, for the opportunity of individuals who were unsuccessful in passing the licensure exam in 3 or more attempts within a score no less than 5 points from the required 70. They could enter into this program and receive their license. That was removed in September of 19 when we moved to BHEC. So that is no longer a program that we will be dealing with. So the only path to licensure at this point is education and exam by certification by exam. So then finally, again, report from Rules Committee, that being Ms. Mosier.
We met on March 26th of this year. We did make some recommendations to some of the administrative codes, specifically 781.401, 781.404, and 781.412. Those items and what those recommendations were, I do believe are in our agenda for today under agenda item number 13.
Okay, thank you, Ms. Mosier. All right, that concludes agenda item number 11.
Before you move on, Chair Brumley.
Yes.
Ms. Andrade had requested assignment with the Ethics Committee. Do you approve that request?
Yes, I will approve that request.
And then do you have a committee assignment or suggestion for Ms. Swartz? Or Ms. Swartz, if you have a preference, if you would like to let us know about that.
Yeah, tell us what you're interested in.
There's still room on any of them?
Oh,
or are there only certain?
I believe there can be room on any of them if is in any place.
The Rules Committee?
The Rules Committee, all right. Ms. Mosier, are you willing to accept her over at your place?
Yes, I am. Welcome aboard.
All right. So we will appoint Katie Andrade to the Ethics Committee and Jennifer Swartz to the Rules Committee.
Thank you.
Now,
Thank you.
That gives everybody a place. So y'all may receive information between meetings now concerning situations relevant to the committee that you're on. But don't fret if you don't get anything. It just means that they're taking care of it at the office level. So, all right. So now that will move us to discussion item number 12, which is the jurisprudence exam. Again, that was included in your materials, and looking through it, it's pretty much the same as always. You know, it's a good refresher, and then it's too long between the questions, and that's going to be there forever because you are given credit for 3 CEUs for taking the jurisprudence exam, and under statute that has to take so long. So it's there. It is required for licensure. So, and we do also use it as a refresher sometimes for actions against licensees. So any questions about the jurisprudence exam?
I can provide an update on the update to the jurisprudence exam for the most current rules. I am this close to getting that to the vendor, and as soon as the vendor has that up on a staging site, I will provide you with a login that you can take the exam and see how the user experiences it and proof that in that regard. So I hope to be sending that to you in the next couple weeks.
We can't wait. That sounds like fun. So,
Wonderful. Will we get CEUs?
probably not.
Will we get CEUs?
If you pay the $40, you may get the CEUs. Yeah. So, all right. Thank you for that, Sarah.
Okay. Thanks for clarifying.
Yeah. Thank you for that information, Sarah. And again, the jurisprudence exam is a tool that is required, and it does provide information. And I want to thank Sarah and her group for working on updating and getting it current with our rule set as it exists now. So that will be even more important to future exam takers. All right, so that takes us to number 13. Get my glasses here, it looks long. So discussion and possible action regarding recommendation to the Texas Behavioral Health Executive Council concerning Amendment 22, Texas Administrative Code, Section A, concerning board minutes to align with operations if board chooses to post recording of meeting instead of creating and posting meeting minutes. Do we need to take these one at a time, or?
It's up to you.
Let's do that. Let's just take these one at a time. So Sarah's sharing her screen so we can see.
And Chair Brumley, if I can just jump in and give a little
Absolutely.
background. This rule didn't go through the Rules Committee, but the purpose of this is based on what you voted on earlier today. Since we won't necessarily be requiring the written minutes, we'll be putting that on the YouTube channel. We'll be having the audio and video recordings in order to get away from being required to do the written minutes. We will have to repeal this rule. And so that's essentially what this proposal is before you today.
Okay. So
This Chair Brown, this also means that we will have to continue doing the written minutes until this repeal goes through. So I misspoke earlier if I left the suggestion that, we get away from written meeting minutes today. We can't until this rule is actually repealed.
Okay. So in this instance, we will, since this is coming, well, we still need to take a motion. So do I have a motion to repeal 781.206?
I make a motion to repeal 781.206.
All right. Do I have a second?
I'll second.
Okay. Martha seconds. All in favor signify by saying aye and raising your hand.
Aye.
All right. Seeing as that is approved, we will move on to 781.401. Qualifications for licensure to implement board policy that at least one site must provide a minimum of 4 hours per week in which the LMSW delivers assessment, diagnosis, and treatment to remove redundant text that requires supervised experience to occur no earlier than 5 years before date application for LCSW is received in 781.406, and remove text concerning requirements for licensed master social worker, advanced practitioner. This is what Martha was talking about earlier, if I'm correct. Is that right, Martha? Martha, you still
Yes,
there?
that's correct,
Okay.
Brian.
Okay.
Yeah.
All right. So Patrick or Andrew, Patrick, did you have anything to say on this one?
No, not just real briefly. We went through the rules committee on this one to make some of these changes. The things I think that we added post the rules committee was to take out the advanced practitioner qualifications or requirements to get licensed, like the experience requirements. Since we're not issuing them anymore, there's really no purpose for them to be in the rule anymore. So we deleted those out, as you can see there in subsection B. That just seemed like it was helpful to pare down the rule where it's unnecessary.
Okay. Now I think, and my parliamentary procedure may not be correct here, so y'all correct me if I'm wrong. Since this comes from Rules Committee, do we not necessarily need a motion in a second?
You do need a motion to, if this looks acceptable to everyone, we can then propose this up to the council to then get it published in the register. So these are all.
I want to point out one thing and make very clear to the board and members of the public who are watching. You see that there's a provision in there in 1C where we struck through, it says supervised experience must have occurred within the 5 calendar years. That is not repealing that requirement. That 5-year requirement still exists. It's just in Rule 406. That was just a redundant sentence in there, and we're trying to stop redundancies in the rules. So I just want to make clear we are not repealing that 5-year requirement. So don't everybody start thinking you can apply with something that happened 20 years ago, experience 20 years ago, because that's not the law still.
Right. And I appreciate that clarification. And one of the things for the public as well, as this group is working diligently to make the rules clearer and a little more concise. And that's why we're taking these steps. So all those in favor of this, accepting this as written, would someone please make a motion? 781-401.
I make a motion to accept it. 781.401.
Okay, so we have a motion. Do I have a second?
I'll second.
Okay, I think Katie and Martha both seconded, so we'll move forward. All those in favor of accepting the changes to 781-401 as described, please signify by raising your hand and saying aye.
Aye.
Any opposed? Seeing none, we will accept 781-401. Now we move to 781-404. Concerning recognition as a council-approved supervisor and the supervision process, to clarify minimum requirement for supervision hours, to delete sentence defining month, and remove certain reference requirements for the LMSW AP. So Sarah has it shared there. Patrick or Martha, y'all want anybody have anything on this one from rules?
This similarly went through rules, and a lot of the proposed changes were adopted under rules to sort of simplify the licensure requirements and streamline them, and also take out, staff went back through and took out a lot of the references to advanced practitioner requirements for licensure to streamline the rule further. So.
Okay. And for the public out there, if anyone wasn't aware, the LMSW AP is no longer a license that is offered. So that's what Attorney Hyde is speaking to in this situation. So do we have a motion to accept 781-404 as described?
I make a motion to accept.
So thank you, Dolores. A second?
Second. I'll second.
Second by Audrey. Okay. All those in favor is accepting, please signify by raising your hand and saying aye.
Aye.
Any opposed? Hearing none, the motion carries.
I will tell y'all that particular rule change will help the licensing staff out, because one of the things that rule does is the ratio of supervision to supervised experience hours, the 3,000 hours, that's it was extremely confusing and very difficult for staff to administer because we actually had two different ratios and it got all befuddled and mixed up, and this will greatly simplify that process for staff. So.
All right. Well, thank you to the Rules Committee for working that out. 781 404C3 regarding documentation of qualifications for licensure to ease reinstatement application requirements such that supervised experience must have occurred within 5 calendar years immediately preceding the date of an initial or upgrade application, and that's it. I guess "and" was just left on there.
Let me give y'all some background on kind of why this change is coming out of Rules Committee. Remember now we have an application for reinstatement. So if you retire a license or you let a license expire for whatever reason and you want to come back, the way the rules are worded right now is an individual who was previously licensed with us, in other words, a known quantity. We know how they have performed in the past. We know that, you know, that if they were problematic, if they were trouble, or if they were not, which candidly, statistically speaking, y'all are a very well-behaved bunch. We don't really have any problems with y'all. So what we were running into, though, is you've got a known quantity, somebody who was previously a licensee, yet they were not able to rely upon all the years of experience that they had as a licensee, and the 5-year rule would then operate to make that individual go back and redo supervised experience in order to get their license back. And I'm like, that, you know, we all talked about it and we were like, that doesn't make a lot of sense when you've got a known quantity, a previous licensee who we can look at and see their track record. The good thing about the reinstatement rule is if there is some question about the individual, you can always make them go back and redo it anyway. The reinstatement rule gives you that authority, but it just takes away this blanket operation. The way it works right now, it gives you have greater discretion for dealing with somebody who is, again, a known quantity. So that's why we're going this route, why we're asking for this change, so that we can expedite people who were once licensed with us back into the workforce, because we don't really have concerns about those individuals.
Okay. So Daryl, an example of that, if I forgot to renew my license and it became apparent 3 years from now that, you know, I moved, changed addresses, and all those bad things happened that I didn't let the board know about, but I hadn't committed any crimes and I'd been a good person before, I can come back 3 or 8 years later and request reinstatement.
Correct. And
as long as I've been a good person.
Right. And even, you know, even if, let's say you had some ticky-tack violation, you know, on your record from way back when, you still have the option of saying, well, okay, we'll let you back in, but you're going to have to jump through this extra hoop to get through. You've got the full spectrum of what I call eligibility order. You could make them do an eligibility order to get back in. If there was something that you just weren't sure of, they're not kind of screwed over by having to go back and redo all the supervision, but you've got complete freedom to address whatever that particular area is without really imposing this pretty significant financial burden on them, having to go back and redo supervision. So,
and is that the one, and I haven't looked at it in a long time, but is that the one on the chart fee that's out there that's like a $500 fee?
Yes. Okay. Yes. And of course, the reason for that is we don't want people who go past their expiration date. We don't want that cheaper than the renewal, the late fees, or otherwise they'll just wait till it lapses. And then you're kind of encouraging practicing on a delinquent license because they'll just wait it out and then apply for reinstatement. That's why that is like that.
Okay.
In case anybody's wondering.
Yeah. All right. Thank you again, Rules Committee, for working on that one. So we would entertain a motion in a second to approve. Go back. It's 781 406 C3.
I make a motion to accept 781.406 C3 as is.
Okay. A second, please.
I'll second.
Dolores has a second. All right. All those in favor of accepting as presented, please signify by raising your hand, saying aye.
Aye.
All right, motion carries unanimously. So moves us to 781.412 B and C concerning examination requirement to align with recent operational changes that moved pre-authorization process to register for exam from the council to ASWB, which is the Association of Social Work Boards, and with the council's 882.6 limitation of number of examination attempts. The rule change also allows staff to accept an applicant's ASWB national examination score that is dated no more than 2 years before the date the initial or upgrade application is received. So who's going to talk about this one?
I guess I'll interject on subsection B. The first version was what went through the Rules Committee and was approved for the Rules Committee. After the meeting, we kind of got to looking at it and thought there's some rule drafting guidelines, and we put together a draft that we think it fits the sort of model language that they would typically use. I think it essentially says the same thing. I think both Bs are acceptable, but after the fact, after the Rules Committee had looked at this, we said, well, there's probably we thought a little bit more of a precise way to word it, and so that's why there's that second B there, just as another option that staff would recommend. Is, not to say it's better, but I think it's a little bit more direct. So that's why you see two subsection Bs there for you to look at. But this goes along with exactly what Daryl was just talking about with the previous rule. This helps implement that same sort of scenario, I think, as well.
Okay. Any information on the other section of this concerning number of exam attempts? This is all wrapped up into this second part of B.
Yeah, that subsection C is already covered in a council rule, so it was sort of a repetitive section. We already have a rule. It's in the council's rules about retaking exams after so many failures. So
which is based on a statute. So
right,
that governs all the professions now. There's one statute that governs that across the board.
Okay, so Patrick, for clarification, we are voting to accept the changes, but also voting to accept the second version of 781.412B.
You can certainly choose if the board wants to go with the first B. You certainly can. We would recommend the second B. We think it says the same. It has the same effect. We just think it's a little bit more direct, a little bit more clear. But yeah, we would definitely want to ask that you consider them and recommend sending them to the council for proposal.
Okay. So do I have a motion to accept 781.412B, the second version, and C?
Make a motion to accept.
So Dolores has made a motion.
Second.
And who did? Oh, Audrey made the second on that. So all those in favor, please signify by raising your right hand, saying aye.
Aye.
All right, it does carry. And I know, so now that one's carried, just for my simple mind, I think we had a situation where this came before the board because we had an individual who had taken the ASWB exam in some other northeastern state, then came to Texas and made application and wanted to bring that score, but we didn't really have a pathway to do it. So now that takes away that. I mean, if it's within the last 2 years, it ought to be acceptable. They can take the test anywhere, and then that score is portable to us. I won't say everywhere, but at least to us in Texas. Is that correct?
Yes, and what this also helps with is when somebody is applying for, again, reinstatement. A lot of these rule changes revolve around that reinstatement rule. We're trying to tweak it so that we get known quantities back in the workforce and delivering services in this field that has such a massive shortage. And the way the rule used to be worded, you really, you had that 5-year problem, and then you also had the exam problem. When did you take it? Well, chances are a licensee, they won't have taken the exam within a year. It's unlikely you get licensed and then you drop out, you retire your license within a year. So you had this funky dynamic that was costing people a lot of money, and it was really slowing the process down. So this is designed to get that funkiness out of the equation. We can get people, excuse the vernacular, but get people back into the field as quickly as possible.
Well, as long as we can be less funky, I guess that's okay.
It's probably not the best way to describe it, but it was all I had at the moment.
I hope that makes headlines somewhere. Social work board is now less funky. So, all right. So we'll move to item number 14.
I had a question.
Oh, yes. Go ahead.
Sorry, I just wanted to know, so they never passed they never got the license in the other state. They just passed the exam and they're moving. And so it's almost like reciprocity between the states, or?
I don't remember the particulars. I don't think the individual that I was talking about that I read that, I don't think they had ever gotten, I think they took the exam, but they had never gotten licensed, and it was something to do with a military spouse too. I don't know. There was a whole lot of mixed up stuff in that one.
In general, if an applicant takes the ASWB exam in another state, they can contact ASWB and ask for that score to be transferred to the Texas jurisdiction.
Okay. Thank you.
All right. Any other questions on any of those that we just worked on? All right. So we'll move to item number 14, which is discussion and possible action concerning safe harbor forms. A, the clinical supervision plan, and B, the non-clinical supervision plan for independent practice recognition form. So I know those, I got information from Mr. Spear that those had now been available for online applications. Is that what we're discussing here?
Well, what I really want to do is I want to make sure that the format, or you all are comfortable with the form of it. When we changed the rules to no longer require approval of the supervision plan, what I did is I got with NASW, Will, Francis, and I worked together to come up with what we thought was a good safe harbor form. In other words, if you use this, you can take comfort in knowing that it's going to be fine whenever you're supervisee, and when they submit it for licensure, we're not going to come back and go, oh, that plan's deficient. Doesn't meet requirements. You're not going to get caught on the back end if you use this. That's why I call it a safe harbor form.
Okay.
And so I just want to make sure y'all are okay with it. It kind of has y'all's blessing. That's really the purpose of this. Make sure there's no objections to it.
Okay.
And I will say, after reviewing these, I did like them. I think it is very clear in terms of what should be agreed on and what that looks like to be under that supervision plan and get that submitted and approved. So it really is a good document, I thought.
It is very clear. I mean, it's self-explanatory when you read through it.
Yes.
I don't think anybody would have question, or as Daryl talked about, that worry about, I'm going to do all of this, get to the other end, and nobody's looked at it, and then it's going to blow up on me. I think that takes that fear away.
And one thing I want the public to understand is this is a kind of a minimum acceptability. Now, your supervisor can say, well, that's what the board says is a minimum, but by God, I'm going to put some extra stuff on you.
Yeah.
That's fine. We're not saying that you can't go outside or you can't change this form up. It's just as a minimum, we're guaranteeing you this is a safe harbor. You're okay if this is the minimum that you use. But your supervisor they're the supervisor. They can add more to it if they want to. So everybody just needs to understand that. So don't go to your supervisor and go, what you're wanting me to do isn't on this form, because he or she can add more if they want to.
Don't send us emails complaining because they want you to do more.
Yeah, exactly.
That's the crux of the supervision is that person is responsible for your learning, basically your education out there. So and I appreciate and I think the public also needs to know that we do try to do our best to work with NASW and other stakeholders out in the community to make sure that we as a regulatory board understand the needs of what the practicing public is looking for. And NASW is a good help, along with several other organizations that we also work with. So thank you, Daryl, for doing that. So can we entertain a motion to accept the safe harbor forms, the clinical supervision plan, and the non-clinical plan for IPR?
I'll make a motion to approve the safe harbor forms for clinical supervision plan and non-clinical supervision plan for independent practice recognition.
Okay,
I second the motion.
and Audrey has seconded. So all those in favor of approving agenda item number 14, safe harbor form, signify by raising your hand and saying aye.
Aye.
It does carry unanimously. So thank you for that. Number 15, discussion of possible action regarding news reports of migrant children held at the border. And if memory serves, I think specifically, I believe, is it Ms. Rogers who wants to speak specifically on this agenda item?
Yes, I just wanted to bring it to everyone's attention. I was just curious about the issue and where we fit. I know we deal with licensing and social workers, but we also touch on personal development and ethics, things of that nature. And I just wanted to know if this would be something we would talk about in the future, and probably put standards in for social workers who are already right now working with the children. So I was just curiosity for me, and just discussion, just so if it becomes an issue like later in the future, we can be better prepared.
All right. Ms. Rogers, this is, it is something that is clearly newsworthy. And it's one of those situations where, I'm not nearly as impacted by it living in the very northeast corner of Texas as individuals who live along those border counties and reach on up several hundred miles into Texas. But as social workers, as a regulatory board, I think we are more geared towards working with licensees and making sure that there is education available, and we could encourage providers to develop training, to approve CEU courses that deal specifically in working with migrant families, refugees that are making their way through Texas. Anybody else has any other agenda item, any other input on this agenda item? I'll be sure open to hearing it. But as far as making directives or things like that, I don't think that's an area that the board really fits. And if I'm wrong, somebody please speak to that.
This is Martha. I agree with what you're saying, Chair Brumley. The other comment that I would make is regards to the question about should we be putting practice standards in place for this specific population. I don't see that as a part of what we're required to do as a regulatory board. Our job is to provide regulation standards, statutes for all social workers that are practicing at different levels and with different populations, different demographics throughout the state. I think the request for practice standards related to that, continuing education, skill development within that is a very appropriate thing to be looking at and developing. I think that should come out of more of Texas NASW or National Association of some Social Workers. There's also, in most areas, there's other specialty groups that are putting those things together. So that's where I would look for that development of those practice standards, education, skill development, competencies for this specific population.
Right, thank you. And one thing that we need to consider is, if in fact we were charged or asked by the authorities that sort of grant us the power to work, the legislator, the governor, BHEC, any of that, for information or help or resources, I think we're absolutely all able to discuss or work on that area. But, being being directly involved in working with immigrants and refugee families is something that we would deal with, you know, if we got complaints or if we got concerns from the public about how social workers were dealing with that, we could then effectively, you know, deal with those issues. So, Ms. Rogers, does that help answer your questions, or do you have more?
That does. That
Okay.
helps. Thank you.
Anything else on that agenda item number 15?
No.
You know, what, I don't know how to find this out, but one thing that I have always struggled with, I get a lot of emails that talk about providers wanting to deliver services to individuals situated in Mexico or various other countries, but I don't have any contact with my counterpart in Mexico. I don't even know who the regulatory authority is down there. I can tell you about Canada and a lot of Europe and New Zealand, but I don't know about our southern neighbor down here. So that might be something, just as a point of utility to me, it might be helpful if anybody, if any of you know who I would need to reach out to in Mexico for the regulatory authority for social work, or really any of the other mental health boards for that matter.
Yeah.
So if anybody's got that information, I wouldn't mind y'all shooting it to me, because that could be useful. I apologize, I went off topic a little bit there, but y'all were talking about this, it made me think of it. But if anybody's got that information, shoot it to me, because I could use that.
Yeah, absolutely. So anybody in the public or on the board, or for that matter, part of any other organizations, let us know if there's information that could help Director Spinks deal with that. So, okay. So that really doesn't require action. So we'll move on to number 16. Report from the board chair concerning current challenges and accomplishments, lawsuits, interaction with stakeholders, state officials, staff, committee appointments, functions, workload, board members, conferences, general information regarding the routine functioning of the board. You know, in general, since our meeting back in April, I don't really have any updated information concerning any situations that's going on currently with the board that's not included on today's agenda. So having none from me, I will move on to agenda item number 17. And as I do that, I want to say, you know, thank you to the folks that do the daily work out there, the attorneys, the office staff, everybody. That's really the reason I don't have a lot to talk about, is because they take care of it. And if there is information, they've done a real good job during this virtual work period of shooting us emails, dealing with things, you know, as they happen. So I think we've been very effective in dealing real time with things as they come forward to the board. So thank you all for doing a good job at that. So number 17, report from the board delegates to the Texas Behavioral Health Executive Council regarding activities of the Executive Council. Well, again, that would be myself and Mr. Morris, and I see Ben's out there. So I don't have an update from BHEC. We're gonna meet in August and talk about a lot of the things we talked about today. Ben, do you have any input as far as what's going on with BHEC?
Just waiting for that next meeting.
Okay, so we'll move on from that one. And then discussion, agenda item number 18, discussion and possible action regarding Attorney General opinion regarding council's authority to adopt rules to impose disciplinary action for certain discriminatory conduct by licensees. So I think most of you, I mean, it's in our packet too, if you didn't already have it. Attorney General Paxton made a ruling concerning or made a finding, a non-binding finding concerning the request by Executive Director Spinks concerning rules related to discriminatory behaviors. So who wants to really talk about that?
I think probably the best option to start that discussion is we probably need to go into executive session so that we can talk about what the opinion says, what the effect of an attorney general opinion is, and what the legal ramifications are depending upon which way we go. So we really need to be in executive session on that to discuss it.
Well, so hearing that, since we are now in open session, the board will go into closed session at this time pursuant to the Texas Open Meetings Act on agenda item number 18 of the July 9th, 2021 meeting to be considered in closed session and this to discuss the Attorney General's finding concerning the discriminatory actions. So to all members of the public in attendance, you may stay logged into this Zoom meeting. The board members will leave, and once the board's closed session is finished, the board will rejoin this Zoom meeting. The date is July 9th, and the time is 10:12 a.m.
So as I understand it, I will send the board members of Zoom meeting request. You'll get that by email in just a moment. And they will leave this meeting so that your video and your audio won't be on for this meeting.
And I have an email prepared to send everyone with the link for the closed session Zoom. Chair Brumley, I just wanted to clarify. I believe one of the reasons for going into executive session was to receive legal advice from board's attorney under section 551.071 of the government code. Is that correct?
You are correct, attorney.
Okay.
Yes, I skipped over that bullet point. I'm sorry. That is correct.
So you'll receive an email from Attorney Patrick. Thank you.
Sarah, I'm going to make you the host. I think right now I'm the host of this. I'm going to shift that over to you. You will leave your the webinar open in your office, and then you can come down here with me in mine, or you can go with Brenda wherever you want to.
Okay.
And then because I will then log out. But once I shift the hosting over to you, I'm going to leave. I want you to stay, Sarah, make sure the meeting doesn't end. We don't torpedo this thing. I want to, but the rest of you can go ahead and start logging out if you want to. And then Patrick, you're going to send that link out to them.
I just sent it.
Okay. Okay, Sarah, you should now be the host.
Okay.
Right, and I'm going to log out now.
Okay.
Okay. The board is now reconvened in open session at 10:59 a.m. on July 9th, 2021. We will now take up agenda items as discussed in closed session, which is agenda item number 18. And I will defer to Executive Director Spinks for information.
Okay. What I'd like to do before we start, take any kind of formal action or decide what to do here, I just want to kind of give a brief explanation of what some of the options are and kind of how the agency is currently interpreting the rule on the books. I think it's important for everybody to understand that obviously the question before the board this morning is the rule that's on the books. The Attorney General has opined that we do not have statutory authority for certain of those terms, as has been stated by several stakeholders in the public, and as we've discussed. An Attorney General opinion isn't necessarily binding on an agency. It's persuasive, but it's not binding. But, so the decision we're going to have here today is whether or not to make changes based upon what AG Paxton has, make changes to the rule based upon what AG Paxton has opined. Now, I want to talk mainly to the public for just a second about what does it mean if I think we all know what it means if we decide to make changes. In other words, the changes would have to be drafted up. They would have to be brought back to the board for review. Then those changes would then go through the regular rulemaking process. They'd go up to BHEC, would have to be published in the Texas Register and so on, for public comment and all that, just like any other rule change would go. But what happens if the board elects not to make any changes here today? In other words, take no action. That means that the rule that is currently on the books would stay in place. Nothing would change, in fact. And the rule that is currently on the books is what contains the prohibitions against discrimination. But I think it's important that we all understand, kind of given the different views that have been expressed on this particular issue. I think it's important that we all understand that the retention of this rule that's currently on the books as it exists right now is not without there are certain limitations that would still apply to the rule. And what I want to talk to everybody about is, and so that everybody understands how the rule is operating currently with the with the prohibitions against discrimination in it. I want everybody to understand how it operates currently. Right now, the express language of the rule prohibits discrimination against certain categories or classes of individuals with disability based upon gender identity, and expression. But the rule is not, it's not all encompassing. It's not without some inherent limitations in it. Here's what I mean by way of example. The current rule reads: a social worker shall not refuse to perform any act or service for which the person is licensed solely on the basis of the client's age, gender, race, color, religion, national origin, disability, sexual orientation, gender identity and expression, or political affiliation. In other words, if the board takes no action today, that's the rule now. That is the rule that will continue forward. But that rule, by its very terms, I need everybody to understand, by its very terms, is not, it's not without exception. I read the language licensed solely on the basis of, and then fill in the blank. The way we're currently interpreting that rule is if an individual, let's say a provider has an individual who is transitioning from male to female, goes to a faith-based provider, if you will, an LCSW who is a faith-based provider. That individual may or may not have religious proclivities that preclude them from delivering services to that individual. Now, they're not refusing to deliver services based upon some sort of discriminatory intent, but rather the right that they have to express and practice their own religion of their own choosing. And that is a right that we as the state, we have to respect that right as well. Just like it is an important governmental interest to prohibit discrimination, against individuals for various reasons, it is also important and incumbent upon the state to respect the rights of the expression of religion. In fact, it's so much so that the U.S. Supreme Court has just issued an opinion on that in the Fulton versus the City of Philadelphia case, where they restrained the City of Philadelphia from interfering with a Catholic adoption charity's expression of their religious freedoms there. That rule also does not require, so you've got that aspect of it. What I'm trying to say is there's that aspect of it. The rule, while the rule will guard against discrimination against individuals in those protected categories, it does have certain inherent limitations. And one of them is if an individual is expressing a legitimate expression of faith, then obviously that's a protected First Amendment interest that has to, the anti-discrimination effect of the rule has to give way to that First Amendment right. But there's also another component of the rule that I think it's important that the public understand. And what we don't want to see happen as the agency that's tasked with protecting the public, we wouldn't want to see providers forced into providing services in areas in which they are not competent. And this is candidly, this is probably the most important aspect to understand for the public. And here's an example. Let's say Dr. X, who's an LTSW, their target population or their niche practice is geriatric. They focus, in the nursing homes, if you will. And you've got, again, an individual that's coming to them in transition from man to woman or whatever the case may be. That provider is probably not going to be competent in that particular patient population. And if that provider then says, look, this is not really in my wheelhouse, I need to refer you over to Dr. Y or, whoever, another provider that is competent in that area. What we don't want to do is set up a scenario where an individual could then file a complaint against that provider. Now, I'm going to tell y'all right now, as far as I know, we've never had a complaint filed under this rule. I'm not expecting any kinds of complaints like what I've described here from this rule, because the type of individual, it's been my experience, this is anecdotal, but the type of individual that's brought, that finds their way into a helping profession like social work, psychology, or counseling, usually don't come into this profession with a mindset of how to play gotcha type stuff, to play gotcha law or to kind of weaponize rules against one another. So I can't say that, that I'm terribly worried about it, but at the same time, we do have to, as the agency, we do have to make sure that everybody understands that this rule cannot be used to operate to require somebody to provide services if it's outside their scope of competency or their scope of practice. That in and of itself would violate the ethical codes that everybody has pointed to in support of keeping the rule like it is. So you would put people in a catch-22 where you would be requiring them to provide services that they're not competent to do. We're not going to do that as an agency. So what does that mean? That means that this rule will still operate to prohibit discrimination. You're not right now, nor will you be permitted in the future if the board chooses to retain this rule. You will not be permitted to discriminate against somebody based upon their gender, their disability, or any of the categories listed in this rule. But if you go to somebody and you say they decline to provide services to you either because it's not within their wheelhouse, it's not within their competency to do so, or they have some sort of faith-based preclusion that would prohibit them, that's not a basis for a complaint, ladies and gentlemen. And that's not going to be something that we can prosecute or enforce the rule against. Now, if you've got somebody who is openly hostile to one of the protected categories and they don't have one of those areas that they can claim, it's not a legitimate or it's not a good faith claim of free exercise, or it's not a good faith claim of it's outside my competency, then yes, we can sanction those individuals and we will investigate it. And if it's found to be true, we will sanction those individuals. But what I'm trying to say is I need everybody to understand that when you have a rule like this on the books, there's more than just one viewpoint in it. And as the agency tasked with enforcing this rule, We certainly agree that that the focus of the rule is a very important and laudable goal. We all want to prohibit discrimination. We all want to make sure that folks have access to mental health services and the health care that they need. It doesn't do the state any good if we allow, significant portions of our population to be denied services based upon one of these criteria. But there are just some inherent and natural limitations to what the state can enforce. We have to give way. We have to respect the protections, the rights of free expression set forth in the First Amendment to the U.S. Constitution. We have to respect the natural limitations that competency of providers provide. We certainly wouldn't be doing the public or members of the LGBTQ or the disabled community any good if we force providers who are not competent in those areas to deliver services. That would actually be counterproductive to our mission. You don't want that. You don't want to live in that world. And so I mention all of this because I want everybody to understand how the agency is currently interpreting the rule. We are interpreting the rule to mean you cannot discriminate against these individuals. But we're also interpreting the rule to say that if somebody is making an accusation of discrimination, it has to be an accusation of pure discrimination. You cannot file complaints on providers if they are expressing a constitutionally protected religious view, or if the individual if you would be requiring the individual to practice outside their scope of practice or competency. We simply cannot do that. I don't think that's anybody's intent, to be honest with you. It's just sometimes this discussion, because of the politicization of it, I think it can take us beyond what everybody probably already inherently believes or inherently knows. I suspect if we polled everybody out there, everybody would say, well, yeah, that's not my intention. I'm not saying you should force providers to deliver services outside their scope of competency. That's very foolish. But I felt like it was important to kind of make that clear, that how the agency, how staff are viewing that right now, so that you understand that if the board chooses not to make any changes to the rule, that's the prevailing view. That's how the rule will be applied going forward, so that we all understand, kind of how it's viewed and how it's operating. So that's really all I have, Mr. Chair. I just wanted to kind of make that point. And of course, I'll answer any questions that the board members have about anything that I've said.
Okay.
So if y'all have any questions, let me know.
Anybody have any questions of Director Spinks? All right, seeing none. We will now take agenda item number 18, discussion and possible action regarding Attorney General opinion regarding council's authority to adopt rules to impose disciplinary action for certain discriminatory conduct by licensees. So as this is an agenda item, it would require a motion to move forward. All right, seeing no motion, agenda item number 18 basically dies and will remain in force as it currently exists. So thank y'all for that. As we move on, one of the things that I will add here is Director Spinks did a good job explaining, and in basic social work terminology, we're really looking here at scope of practice. We're really looking at, I want to, number one, be ethical, but I also need to be very effective in the practice methods that I use. And I want everybody to understand that that's what we as a board absolutely expect out of all the social workers out there. I know there's been lots of discussion about this topic, and I would encourage anybody and everybody who feels the need to carry this forward, to do so in the pathways that change can be made. If you feel led to do so, you contact your legislative representatives and you talk with them about the rules and the efforts that we make here to make those changes. I do believe we use basic common sense in everything that we try to do, and I hope that everybody is accepting of that. So we'll move forward to agenda item number 19, which is report from board administrator concerning operations, organization and staffing, workload, processing, statistical information, status of rulemaking, customer service accomplishments, inquiries, I thought that said injuries, but inquiries and challenges, media, legislative, and stakeholder contacts and concerns, special projects, general information regarding the routine functioning of the program. So a lot of stuff there. So who's taking that? Sarah, Tim, Daryl?
This is Sarah.
Okay.
So I just wanted to remind the board members of where we are on certain rulemaking processes. The social work, the Council on Behavioral Health Executive Council has some new rules that became effective June 1st. And the Social Work Board has rules that became effective on June 1st, and they're on the agency news, the board's news page. So you can see that. We also have an open call for public comment regarding rules in chapters 881, 882, 883, and 885. And there are instructions on the website on how to submit that public comment. We have, thank you to Brenda Skiff. She updated the consolidated rulebook webpage, consolidated rulebook. So it includes the most recent updates. Also wanted to bring to your attention the Executive Council has transitioned into a web-based email protocol. So if you go to the Contact Us webpage and scroll down a little bit, you'll see the Email Us button, and that brings up a form that you can complete, and you can select the topic of your inquiry, and that will direct it automatically to the staff that needs to address that particular topic. So we encourage everyone to use that email format. I have had a significant increase in inquiries regarding out-of-state license holders who wish to provide teletherapy to a client who is in Texas. And so we're dealing with that. I just wanted to state that a Texas license is required for a client who physically is in Texas. And my understanding from Attorney Patrick is that a Texas license is required for a practitioner who is physically in Texas. So just wanted to bring that to everyone's attention. Also, beginning, an email update was sent regarding a change to online applications. There's now new capability for submitting an application to recategorize from LBSW to LMSW and from LMSW to LCSW. There's also an online application for supervisor status. After August 1st, only online applications for those categories will be accepted. So bear that in mind. And also for the board members and for the public, we are anticipating that the suspension of particular Open Meeting Act provisions that allow us to do these Zoom meetings while COVID was more prevalent will be ending August 31st. So after September 1, we will need to look at either a slight change in our technical web-based meetings, or we'll have to look at in-person meetings. Daryl, did you want to add anything on that point?
Yeah. After September 1st, it'll become a little more difficult doing virtual meetings. The chair will have to be here because wherever the presiding officer is for the meeting, that location has to be open to the public. There's also another minor change in that after September 1st, like Ms. Rogers right now, she doesn't have her camera on. We cannot do that after September 1st. The only reason we can have some members on phone or through non-video participation right now is by virtue of the governor's suspension of the Open Meetings Act. after September 1st, everybody will have to be on video. The only way you can use audio only is in a true emergency, if a hurricane wipes something out or something like that. So it becomes a little more difficult. And the reason it's more difficult is because of the lack of facilities here in the hobby building where we're at. We had a conference room, but we've had to cannibalize that for cubicle space for staff. The way I think we're going to work it is we will have the presiding officer sitting in what used to be the conference room, which is just, they'll be sitting in amongst, 7 or 8 cubicles right now. We'll have to set up some chairs so that if members of the public do want to come, they can come sit in the chairs. It's going to be really weird if you choose to come to the meeting in the public. I would not encourage it. I would encourage you to still appear virtually, because it's just you're going to feel awkward. And then as the chair, you're just going to be sitting there with a laptop and a screen, and we'll have to have a screen that the public can see. Awkward is the best way to describe it. The reason I think we're kind of limited to using the stuff here in the office is Wi-Fi capabilities throughout the hobby building are so poor. I hate to chance a meeting on state government Wi-Fi in this building because it comes and goes so bad. So go ahead, Chair Brumley.
I was going to ask, is there reason or possibly opportunity to use another location to have a meeting? Talk about that.
Yeah, you can. Where that, and I'm excuse me, I'm actually kind of working with TDLR right now to see if we could use their room. The problem is they're back in full swing too now. So their facilities get chewed up or get eaten up by they've got, I don't know, 40 or 50 advisory boards. So trying to squeeze in over there is really difficult. Of course, if the special session weren't going, you'd have full access to the Capitol. The problem is, like, we're doing Zoom right now, and it's very easy to do. Sarah can run this whole thing herself. It's different, though, if you're in a room over at the Capitol, because we're not running the tech at that point. Somebody else is, and it may not be Zoom. How do we get that? How do we make sure that the public can come in and comment? It can get very difficult very quickly, and I don't want to lose the ability to record our meetings on video and be able to post them to YouTube. I personally think that's a pretty good thing to have. I like the way we do public comment here because it increases public participation. It's a pain in the butt if you have to come to Austin, Texas, just to give 3 minutes worth of comment. And I would rather avoid that if we can. So you run into just inherent technical difficulties if we go someplace else.
Okay.
An option to still do this? Because I wasn't clear on the email.
Say that again, Dolores. I missed part of that.
Is it an option to continue this? Because it wasn't clear on the email.
It will be, but there's just going to have to be some changes. Like if, say, this meeting had happened after September 1st, Chair Brumley would have to be here in our office. Wherever he is sitting would have to be open to the public. We'd have to have some chairs in there. The public would have to be able to see all of your faces, which I'd have to hook up a projector. The public there would have to have the opportunity to comment, not to mention the public that's online about to comment. There's just a lot more moving parts that come into play after that. And then, of course, your faces would have to be visible all the time, because the minute we lose, we can't see anymore, you're out. I mean, we can't count you as part of the quorum. So we could lose quorum real easy if 2 or 3 of you decide I want to eat my breakfast while the meeting's going. Well, we just lost quorum. So we have to be real careful about those types of things post September 1.
So would this also apply in terms of the chairs of any of our committees having to be there in Austin and have it open like that? No.
No, the committees aren't subject to the Open Meetings Act because they're not a quorum of the board president.
Okay.
All right. Thank you for that. Any further on agenda item 19? None from Sarah, Daryl. I see Tim Spear is out there. Tim, any update on board activities as far as backlog or anything like that you are prepared to offer?
I don't have any updates. with the changes that have been made by BHEC regarding moving the exam eligibility portion over to ASWB, et cetera, we're doing much better where backlogs are concerned. So the level of comment from the legislators that we've been getting is way down compared to what it was when we started. So other than that, I have no comment.
All right, thank you for that. I can say social workers as a rule must be pretty good detectives because they can use their skills and find my email and phone number, and those inquiries that come directly to me are also way down. So if we take that as a guide, I think we're doing our job a little better about getting licensees in and out through the system. So thank y'all for that. All right, hearing no further action on 19, we will move to agenda item number 20, which is discussion and possible action regarding future priorities and activities of the board. So any board members have any input as to agenda item number 20? Seeing none, Sarah, Daryl, anything on number 20? Nothing there. All right, so that moves us to agenda item number 21, which is public comment. And I will turn over to Sarah as she controls the waiting room.
So for public comment, if you have logged in with your computer, please use the raise your hand feature to indicate that you'd like to provide public comment. Those who raise a hand will then be unmuted to give their comment. After all who have raised a hand have had the opportunity to provide public comment, I'll call upon those who have joined the meeting by telephone. When providing your public comment, please identify yourself and whether you are speaking individually or on behalf of an organization. All public comments will be limited to 3 minutes unless otherwise directed by the presiding officer, Chair Brumley. So with that, I will see who has raised a hand. Mr. Francis, you have public comment?
Yes, thank you. My name is Will Francis, and I am the Executive Director of the National Association of Social Workers Chapter. I'd just like to read a short statement and then just add some other comments. But I'd like to thank the board for their decision today to keep the code of conduct intact. Your careful deliberation on the issue and for taking the time to listen. The overwhelming majority of social workers across Texas requesting that the board maintain the integrity of the code of conduct is incredibly appreciated. Code of conduct isn't just lofty words. It represents the fundamental values of the profession. It guides practice and it reinforces the concepts that every social worker learns in school about the dignity and worth of all people and their right to self-determination. The Texas Code of Conduct was developed out of the NASW Code of Ethics, and the Code of Ethics stretches across state boundaries, unifies us as a profession, and serves as a framework for every state license. Maintaining the non-discrimination protections in the Code of Conduct ensures that all clients see social workers as an available resource. NASW's concern throughout this process was always less about worrying that these changes would permit social workers to discriminate, and more about not wanting anyone to choose to refrain from seeking help because of a fear of rejection. In addition, the discussion around competency in practice and protected religious views are important ones. Ultimately, a social worker needs to know where they stand so they can get out of the way. And while they can hold any personal belief they choose, that should never provide a professional impediment to anyone seeking help. Thank you again for your service on the board and your commitment to the principles of social work. And just based on the meeting today, I just wanted to add very briefly, if I could, I'm not crazy about that word upgrade. I've been looking for a synonym and not found one yet, so I will continue to search for that. But we are tiered level of licensures. One does not necessarily upgrade to the other. Appreciate your feedback, Martha, on the safe harbor document. That was not done by me. I coordinated many LCSWSs on it, and I will pass along your words. Thank you for that. And just wondering when that was going to get uploaded. I have not seen it in the document yet. NASW has quite a few background materials on migrant children, and I'll be happy to pass those along to Chair Brumley and staff for dissemination of the board so that you all can see some of that information. And then I just want to say, to back up what Tim said, but then to add, big praise to the staff of the board. License questions to me have gone down as well. It really feels like y'all have made a major impact there. Big praise for staff. Just want to say thank you. The area that I now get complaints about are ethics complaints. And I have very large concerns about this. I have people who have made a complaint for a social worker, say, sleeping with a client or committing something incredibly egregious, and it just sort of going slow, very slow towards resolution. There's other social workers out there who have what they determine complaints that are not warranted against them, and they denied tenure at universities, impact their work. I really hope that this board continues to look at the delays and the year-long process it takes to go through the complaint process, and that's something that maybe with the support of BHAC or maybe with resources that you all have can really look into addressing, because the complaints issues is really hitting some people hard. So thank you for the opportunity to speak today.
Thank you, Mr. Francis. Ms. Martin, you have public comment? Sandra Martin, you have public comment?
Yes, am I unmuted now?
Yes, we can hear you.
Okay. I am Sandra Martin. I'm Governmental Liaison for Christian Counselors of Texas. And I think that as I heard the decisions regarding the Attorney General opinion, I think that I heard the best possible result of the situation for several reasons. Number one, I appreciated very much the distinction between the words that are printed and the BHEC's interpretation of those words for two reasons. Number one, our concerns have been, and the concerns expressed to me have been, are we going to be forced to work with clients for whom, number one, we may not be competent for that work, and number two, we may be doing serious violation to our convictions of faith. I appreciated that distinction between these are the words that are on the page, and this is how BHEC interprets those words. Certainly appreciated the fact that no one will be forced to be, as I have said in previous occasions, re-educated in order to be competent in areas that they're not competent in and don't particularly want to be competent in for reasons of faith. I appreciate the fact that at this point in time, no one is going to be forced not to refer someone. No one is going to be forced to work with someone. That's not good for either the counselor or the client. There's no health there. Number two, I very much appreciate, and obviously Christian Counselors of Texas will, that our faith is not going to be considered something not really important at all to the way we conduct our lives in our practices and our profession. It is central to our being, and our being includes our professional being. So the two things I jotted down was not everyone will be satisfied, but everyone will be protected, at least according to the understanding I have today. And that is something to be greatly appreciated by the great state of Texas. Thank you very much.
Thank you, Ms. Martin. Kathy Ryder, do you have public comment?
I do. I'm Kathy Ryder. I'm a licensed clinical social worker in the state of Texas, practicing outpatient mental health for the over 50 years. I represent the Texas Society for Clinical Social Work. I want to say thank you on behalf of the society to the members of the board for holding to the values of anti-discrimination, which are core values of social workers across the United States and are supported by the ethic code of the Clinical Social Worker Association, the National Association of Social Work, and ASWB. We appreciate your diligence and your time and consideration in this. Secondly, I want to join the voices of Will Francis in saying that in social work, we consider LBSW, LMSW, LCSW to have independent scopes of practice, and we want to be respectful of that. So we would prefer that we not use the word upgrade as people change categories of licensure. And perhaps Sarah's used this morning earlier of the word recategorization may be a way to look at it, but I'm like, well, I've been attempting to, other than just say the word change. So if we could look at taking that word upgrade out, we would appreciate that. We certainly do support the board's and BAC's efforts in moving the complaint process forward, because we do not want any consumer of services or any practitioner to have unnecessarily elongated periods of time where a complaint is not resolved. So we appreciate all those efforts that you've been doing. Again, thank you to the board for your service, and we appreciate all your efforts.
Thank you. Virginia Manuel, do you have public comment?
Yes, thank you. My name is Virginia Manuel. I'm an LCSW, excuse me, I'm an LMSW-AP, which I understand now is no longer going to be a part of the licensure. I have been a social worker for over 46 years and have recently retired. But social work has been my life, and I'm very interested in keeping up with what goes on in my profession, and I plan to continue to be involved in works of my profession. I do want to say to you all, as the board, as our board, that I thank you and really appreciate you all defending our current social work code of conduct and upholding our principles and our ethics and working against any kind of allowed discrimination. That is something that has been worrisome, I know, to me, as it has been for other social workers. That is not who we are as social workers. And the idea of a social worker being in practice, whether private practice or at an organization, and discriminating against clients or patients is just unthinkable. So I thank you very much for your hard work and your discussion of this amongst yourselves, and really appreciate you protecting us. Thank you very much.
Thank you. Steve Parks, you have public comment?
Yes, ma'am. Thank you. I just want to echo others' comments and just thank the board for preserving our anti-discrimination ethics within the code of conduct. I think that was awesome. And I also want to echo what Will Francis has said, that I would like more resources put towards resolving ethics complaints more expeditiously. And I think that's the next big tackle for the board to address. Thank you very much for hearing me out.
Thank you for your comment. I see no other raised hands. Let me check one more time. That appears to conclude public comment.
So nobody on the phone?
I only have computer.
Okay.
People have joined by computer. I don't have any phone calls.
All right. So hearing no further need for public comment, we'll move on to agenda item number 22, which is announcements and comments not requiring board action, such as statements regarding conferences and other recent or upcoming events. I know you can find information about ASWB's conference if you go to their website. If Will Francis is still out there, Sarah, if he wants to make comment concerning NASW's upcoming conference. I don't know if Will is still here.
He's raised a hand.
Okay, if Will wants to talk about the NASW conference, we'll take him back live.
Mr. Francis?
Thank you, Chair Brumley. Yeah, I'm hanging around till the very end. I appreciate the opportunity. October 21st through 23rd, we will be having the NASW conference. It will be virtual. I am very excited to have one of our very illustrious and sought after speakers will be Daryl Spinks, who has agreed to speak at the conference. We asked Sarah if she could be there as well, but she's unable to make it. But he's going to give a little bit of background, I think, on the board of BHAC. Have some other great speakers there, have a really wonderful opening plenary speaker who's going to be talking about the intersection of hip hop and personal narratives within social work. All of that is on our website, and I'll be happy to pass that on to Chair Brown. Thank you.
All right, thank you for that, Will. So any board members have any information about conferences, activities, anything coming up?
I also have a raised hand from Kathy Ryder.
Okay, Kathy.
Thank you, Mr. Chairman. The Texas Society for Clinical Social Work annual fall conference will be October the 2nd. We will be focusing on trauma. We are still developing the panel of presenters, and we will be getting that information out. All information is on our website, and we appreciate the opportunity to make the announcement.
Kathy, is that virtual or is it a face-to-face conference?
It's going to be virtual.
Okay, all right. So thank you for that. All
Chair,
right. Yes, go ahead.
One thing I'd kind of let this board in particular know about is in October 4th and 5th, I will be going to DC to sit on the Social Work Compact Technical Assistance Group.
Okay.
This is going to be the group that starts to develop y'all's practice compact, your licensing compact. So
okay,
we're meeting there on October 4th and 5th.
All right, so that's good news that that's moving forward. So yeah. All right, so hearing no other information, Sarah, our next board meeting will be
October 8th.
October 8th?
Correct.
Okay, so our next board meeting will be October 8th. So look forward to, I guess I will be in Austin in a room with cubicles and seeing the rest of you on live here on camera. So thank y'all, and we will now, does anybody have anything else before we take motion for adjourn? All right, so it is 11:41 on July the 9th. So we've been, I guess, going a little over 3 hours. So I will now entertain a motion to adjourn.
I make a motion to adjourn.
I'll make a motion to adjourn.
All right, so I have two motions. We'll take one of those as a second. And all those in favor, please subscribe by saying aye and hitting that leave button down in the right corner.
Thank you.
Bye.
Thank you.